Hi, everyone. Thank you so much for joining the Center for Data Innovation and our esteemed panelists for our discussion of the Online Safety Bill. The Center for Data Innovation is a global think tank that focuses on the intersection of data, technology, and public policy. We have staff in the US and Europe and promote pragmatic public policies designed to maximize data-driven innovation. We're a nonprofit, nonpartisan research institute proudly affiliated with the Information Technology and Innovation Foundation. I want to especially thank our panelists today, who I'll briefly introduce for their public policy work. Each of them is going to bring a really unique perspective to our debate, and I couldn't be more excited to hear what they say about the topic. First, I want to introduce Victoria Hewson. She is the Institute of Economic Affairs Head of Regulatory Affairs and a Research Associate. She's a lawyer and has practiced for 12 years in the fields of technology and financial services. Before entering the legal profession, Victoria worked for a number of years in the UK and Germany, and has also previously held a position at the Legatum Institute Special Trade Commission. Our next panelist is Sam Dimitriou. He's the research director for the Entrepreneurs Network. Prior to joining the Entrepreneurs Network full-time in 2018, he was the head of research and head of projects at the Adam Smith Institute, where he specialized in policy relating to emerging technologies, the gig economy, and tax reform. He also has advised informally on policy issues and wrote a report on tax reform for the all-party parliamentary group for entrepreneurship. Our next panelist is Mallory Nodal. She's the Chief Technology Officer at the Center for Democracy and Technology. She's a member of the Internet Architecture Board, the co-chair of the Human Rights and Protocol Considerations Research Group of the Internet Research Task Force, co-chair of the Stay Home Meet Only Working Group of the IETF, and advisor to the Freedom Online Coalition. And finally, but not least, we have Kate Jones, who's a expert consultant and researcher on human rights and technology. She's an associate fellow at the International Law Program at Chatham House and a senior associate at the Oxford Information Labs. She focuses on cyber and human rights issues and is the author of Chatham House's research paper, Online Disinformation and Political Discourse, Applying a Human Rights Framework. She was formerly based at the University of Oxford after many years as a lawyer and diplomat in the UK Foreign and Commonwealth Office. This moderated panel will try to foster a great discussion on the Online Safety Bill, especially the challenges and opportunities the United Kingdom will face if the proposal is enacted. In particular, we hope to tackle the question of how it will affect encryption, anonymity, and our protected communications online. I hope through this, all our panelists are able to discuss and counter one another's perspectives as we attempt to tackle this question full on. After the moderated panel, we'll follow up with 15 to 20 minutes of questions and answers. Please submit these questions through Slido, as we're keen to hear your questions and concerns. To start off, I'll actually punt it over to you, Mallory, to discuss why online safety regulation is in the news. And for our international users, why is it a focus for the United Kingdom, the DCMS, Ofcom, and Parliament?
Thanks. Thanks for having me. Really appreciate being with you all to discuss this. So this is not just in the UK. I think it's actually pretty global, and that perspective I have because of the Global Encryption Coalition, which is led by CDT and other civil society organizations like the Internet Society and Global Partners Digital, also based in the UK. So we know that these laws are becoming more common. They're being proposed in a variety of different ways. So I think that is why this seems like a good time to reintroduce a long ongoing battle between sort of user privacy online versus what's framed as user safety. And I think it's been a compelling argument to focus on child rights. So that's a component of the bill. But of course, we have the sort of standard other kinds of content like legal but harmful, the terrorist, extremists, religious extremist content, that sort of thing. That we've seen in the past. So it's sort of bringing together all these different issues to try to tackle them together. So again, it's a compelling argument, but it isn't a new one. So I think that this will have its moments. It will go one way or another. We'll have some bill that tackles, hopefully, part of this issue in a way that respects human rights. But even if it doesn't continue in its current form, I think we can always expect in the future to have these sorts of regulations proposed. It's just what we've come to expect with these, I think, really inherent tensions, not just in the UK, but around the world. And would love to hear others' thoughts too about maybe why in the UK it's come out in this particular way. I don't have insight into that necessarily, but it is not alone, is all I wanted to say.
I think it's a good place for Victoria, you to jump in, considering you and one of your partners at the IAA have just written a paper on this. Um, why should we pay attention particularly to the online safety bill? And could you give us just a brief introduction to your remarks and opinion on the bill?
Yes, so Mallory's completely right that this has very much been a global concern for quite some time. It's sort of come to the forefront in the UK because the British government has decided it wants to be a world leader on this front as it sees it, and make the UK, quote, the safest place in the world to go online. And in order to achieve that aim, they have put forward this bill, immensely complicated. I carry my copy of the bill with me everywhere, 250 plus pages long. And they've really turned it into a bit of an omnibus to cover lots of current gripes that politicians have about the internet. So it doesn't just cover the core issues that probably would attract broad agreement, like countering child sexual abuse and exploitation online, and other, egregious criminal activity, but they've widened it out to cover fraudulent advertising. They've included this concept of what's become known as legal but harmful, which we are not yet sure what that's going to be, but there's a pretty good chance it's going to include things like misinformation or perhaps abusive or harassing content that falls short of a criminal threshold. And obviously, alongside all of this, immense powers for our communications regulator, Ofcom, to a level that I guess viewers and listeners in the United States might find quite shocking, that we have essentially a regulator of speech in this country that goes far beyond even what the US experienced under measures like the Fairness Doctrine. And perhaps almost most worryingly of all, the bill also introduces some new criminal offences for sharing certain types of content, which replace our existing communications offences, which are bad enough. And many people were quite pleased that we were getting rid of our existing communications offences, which were based on obscene content. But this switches that around slightly and bases it on harm to the recipient. So these new offences will concern intentionally harmful content, or psychological harm, I should say, or intentionally false content that causes harm. And when you couple that with the duties that are at the forefront of the bill, which are duties on internet platforms to remove illegal content, which in practice is going to be content that they believe to be illegal because they won't be investigating it and waiting for a trial to happen. And you couple that with these new communications offences, I'm afraid the legal but harmful issue pales into insignificance compared to the combined effect of these new communications offences and the rather hair-trigger duties to remove illegal content.
I'd love to hear your perspective, Kate, on the online safety bill, just because I think you and Victoria have ideas that I think could bounce off of each other. Be they agree or not?
Yes, well, thank you very much for having me on the panel. It's great to have this exchange on the bill. I agree very much with a lot of what has been said. I think the British government is keen to be at the forefront of this, and I think that it has seen over the last few years that self-regulation doesn't work, that we live in an environment where currently there isn't enough protection against harms, and therefore it wants to be at the forefront of tackling harms. What I would say about the bill is that in the UK, we've had a very interesting democratic process on its development, and that's still continuing, where we've been through various stages, including in the autumn, the pre-legislative scrutiny of the bill, which was actually quite an effective and hard-hitting process to really get into quite a lot of these issues. And now we have the current draft of the bill, which is being discussed by committee in Parliament, and again, getting an opportunity to tease into some of these issues. And what I would say is, I would share Victoria's views that the bill isn't perfect at the moment, but I do think that it's come quite a long way from its starting point, and that actually the bill is trying to achieve a balance between the various rights and interests engaged. It hasn't quite yet got all of that right, but it's on a path where hopefully we are moving in quite a positive direction. And absolutely, it does give a lot of powers to Ofcom, the government's independent regulator in this area. But I don't see Ofcom as being a regulator of speech so much as a regulator of a healthy information environment. I think there's an interesting question about where you have the guardianship of a healthy information environment. And I think we all agree that governments are not the best place themselves to have that regulation. But we've also seen that the private sector, it's very difficult for them to have that sole responsibility, because it leaves them trying to balance commercial incentives that they quite rightly have with public interest incentives. And so in the absence of any alternative, an independent regulator may be a positive place for that to sit. The question then is how to ensure that it really is independent and that it's able to carry out its duties in a fair and impartial way. And I think that's what we will be looking to Ofcom to develop and use the capacity to do over coming years.
I guess then I'm going to pivot to Sam, considering you work with businesses every day. Do you agree? Do you think that the government is stepping in enough? Do you think they should step in more? And what is the impact of this bill going to be on the people you work with every day?
So I don't think the online safety bill is a good piece of legislation at the moment. I'm pretty concerned that it's not going to become a good piece of legislation at any point. I think it leaves a lot actually down to, actual implementation. This kind of reminds me of the Nancy Pelosi line about Obamacare, and that you need to pass it to find out what's in it. I think, in practice, even as it's written, it could go in many different directions, depending on the choices of Ofcom, how much of a priority they decide to make the enforcement. Will Ofcom even have the staffing to do this? I know a lot of government bodies might be seeing their numbers fall now that there's sort of tough economic times. I think there's a few things that concern me about the bill. So first, I'm worried about what it means for free speech. So I think in theory and in practice, content moderation is hard. So we can debate all day about what is and what isn't misinformation, what isn't a healthy information environment, what isn't, what's unacceptable hate, what's a legitimate view, and so on and so forth. But I think the issue is that even if we can come to a good answer, it's not necessarily likely that we will, but we might be able to. Actually implementing that as a standard is really, really difficult. I remember recently I had my Twitter account suspended for a day because I tweeted a joke mocking an anti-vaxxer conspiracy theory. It was very much a pro-vaccine tweet, but it got caught up in the sort of dragnet as an anti-vax conspiracy tweet. So that took the tweet down. And I think in practice, that's much more likely how it's going to be implemented, rather than, the ideal sort of proper deliberations. I am concerned about the concept of legal but harmful speech. Now, it's a good thing that it's at least going to have to be defined in secondary legislation, so it's not something where companies have to figure it out and then they might get punished after the fact. So that at least removes some of the risk aversion. But I'm still concerned that Parliament will, over time, whatever the moral panic of the day is, will add more and more types of speech for that. And I'm a bit surprised as well by the complacency within the Conservative Party. So, they're at least nominally committed to free speech. They have legislation in terms of campus free speech legislation, but they need to realise that they're potentially not going to be in power after the next election. If you look at the polls, and the party in opposition, well, the leader of that party famously tried to prosecute a man for telling a joke about blowing up an airport now because he was late for his flight or something. It was a silly joke. Comedian spoke out against it, but the guy got dragged through the court system, and that perhaps suggests that the tone around free speech within the party in opposition might not be the same as in government, and that could mean those secondary legislations could lead to real problems in terms of what legal but harmful becomes in the future. And then I think we also have to think about what it means for startups, entrepreneurship and innovation, right? They're imposing a near mountain of red tape, things like producing annual transparency reports, risk assessments of all sorts, the duties around age verification. Are we trying to age gate the internet? What's going to happen when, companies want to enter the UK market? Are they suddenly going to face a lot more regulation than they would outside the UK? And it feels like it doesn't really fit into the wider agenda of removing unnecessary red tape, right? So that by drafting the bill so widely, leaving enforcement up to Ofcom, they're kind of actually giving powers to an unelected regulator. It's not the sort of taking back control approach that we were sort of told about a few years back. So I'm very sceptical that this legislation is going to get to a good place. I probably think that startups and free speech would be better off it was completely scrapped, but I don't think the prospects of that happening is very likely, sadly.
I think there's a lot in your statement there, and I'd love to just see if anyone would like to build off of it, off of your remarks.
Sure. Can I come in there on the innovation and entrepreneurship aspect, which is something that we devoted a section of the briefing that you mentioned earlier that the IAA has published this week. The government, in its impact assessment associated with the bill, estimates that 25,000 platforms are going to be in scope of this regulation. And actually, some business groups think that that's an underestimate. So we're not just talking here about big tech with deep pockets. We're talking about everything from small community groups and forums, specialist forums like Mumsnet, for example, which is really popular but sometimes quite controversial forum in this country, specialist sites, trade union forums, everyone like that is going to be swept up under this regulation with all of the associated bureaucracy that Sam was just talking about. The government's cost assessment is sort of darkly comic in a way. I think they estimate the cost of implementation over 10 years to come out at something like £2.5 billion. But when you dig into the basis of these costs, they built it off estimated legal fees coming in at something like £30 an hour, which as a former practitioner in that field is literally laughable. No business is going to get expert technology compliance advice from a law firm for £30 an hour. So the scale and the burden of this bill is actually immense. And arguably people might say, well, but if it'll keep children safe, if it will prevent all of this horrific racial harassment and plotting of terror, then maybe it would be worth it. But the impact assessment doesn't make a strong causal link really between this policy and the positive impacts that it's hoping for. And I think that's partly because, in a way, the whole gestation of this bill, all the way back, it goes back at least in its current form, probably at least 5 years to a green paper, and even before that, academics have been calling for this kind of thing. But a lot of it, certainly in the political discourse, is based on a couple of quite incorrect propositions and tropes, really. A popular one that politicians use in this country is that the internet is like the Wild West, and it's totally unregulated. And that's just not true. The sort of associated assertion that often runs alongside that is that what's legal offline and illegal offline should be illegal online. Well, it already is. The Law Commission, a specialist body in this country, did a big piece of work just a couple of years ago where they set out to find out what the gaps were and what activities might somehow fall into these loopholes in the online world. And the answer was there aren't any. If anything, online activity is more closely regulated than offline. And I think, to a great extent, what this seems to me is that it's the government outsourcing law enforcement onto digital platforms because they've quite frankly given up on trying to address criminal behavior in the real world, and are simply trying to impose these duties onto platforms with all of the associated burdens on innovation, free speech. We've talked about privacy. We might get onto in a second, but what these duties that the platforms will be obliged to operate, their systems and processes, their age verification, is all going to be extremely intrusive to every single user. Because what's not often widely understood about the bill, it doesn't just apply to sort of public-facing social media. It applies to private messages. It applies to search services. So when you do a Google search, you're going to have to verify your age. And I just don't feel like that can be proportionate in any sense at all.
I wanted to comment on both of those points, actually. I'll take them in turn. The question of proportionality and scope, but then also innovation, which Sam brought up. So I'm a technologist, so I also watch how these technologies develop in standards bodies, where engineers are really focused on making the absolute best products they can, making sure the internet works the best they can in the user interest. And that's one of the reasons why, as a public interest organization, we participate there, also to help watchdog human rights issues from a design and development perspective. And so, of course, these changes that platforms make are not just sort of co-regulating user behavior on platforms. They're going to have technical implementations. Those technical implementations cannot just be geo-fenced in the UK. I mean, they will have knock-on effects globally. So when we talk about the proportionality issues, we're also talking about how while maybe a democratic process, perhaps flawed, perhaps not, has led to a certain bill in the UK, it's going to affect users all over the world that have different realities, different standards for what constitutes safety and a safe place to be online. I mean, that is a different question for countries and communities everywhere, yet those platforms will be making really vast, sometimes incompatible changes to their platforms based on this bill. So there is a huge question of proportionality and the ways in which platforms are going to have to comply, because it's also quite expensive to make these changes, not just to get legal advice on compliance. But then on the question of innovation, I do actually think that there are some changes that platforms need to make. We try to incentivize those changes every day that makes privacy, user privacy, more centric in the design, from the design up, from the low layer protocols all the way up to the social media platforms. We want changes to ensure that overblocking doesn't happen, that there is a sort of tendency to have more freedom of expression, not so much content moderation, or content moderation in very incisive ways. These are all changes that we want. The problem is that unless you incentivize them rather than mandate them, what you wind up doing is actually ossifying these platforms, actually stifling innovation and making them less durable, because ultimately platforms have to be able to change. There are going to be all kinds of security issues, from small bugs in the network that have impact all the way to just threats and security issues we didn't really think about right now, and it will come up later, that we'll have to make trade-offs for in the ways that these platforms operate and are designed with users in mind. And so mandating things now in specific ways is not good, which I understand a lot of the bill is rather vague. I think it's usually invoked as more of a criticism than anything else, because then it leaves so much unknown, so much left up to Ofcom, so much continually still left with the platforms, that it almost doesn't really regulate much, other than, again, trying to sort of freeze in time a vision for the internet that I don't think is a sustainable way of approaching these very social-centric issues. And would very much agree with Victoria that we need to think about how technology might assist dealing with issues rather in the real world, rather than thinking about the online world as something special that we now need to fully engineer and have complete control over. that we need to broaden our view and rather think about, how could we backdoor encryption rather than how could we maybe use technology to solve some of these very large social issues that might include things like careful approaches to content moderation in certain kinds of private systems and so on, but that isn't singularly focused on solutions that may or may not be proportional, that may or not be feasible technically. And so those are just some of the slates of issues that I thought about as I heard Victoria and Sam speak. So thanks.
Yeah, I actually would agree with those points that Mallory has just made. And actually, I think that by my reading of the bill, to a large extent, that is what the bill is aiming to do. It's actually trying to get that balance between, on the one hand, setting out a clear framework, and on the other hand, allowing flexibility for iterative development over time, because these are, as you say, very challenging issues and very fast-moving issues. And we need flexibility in governance of those issues as the issues themselves develop. I think on the innovation point, it's a choice for any society what balance you strike between leaving an open field for innovation on the one hand and in governance on the other. And I don't actually think it's illegitimate to say, okay, here there is a role for governance in tackling some of these really awful harms that we have seen online and some of the terrible real world consequences that have happened. You can either leave those to the market, or you can say, okay, there's scope for government to come in. And personally, I think it's right for government to come in to try to find a way of tackling those harms, working hand in hand with the technology sector and other sectors as well to try to seek appropriate solutions. And I think, you can say, well, actually, whatever is forbidden in the analog world offline is also already forbidden online. But the reality is that we have seen terrible harms happen online. I mean, just to give one example, when I was a child, kids didn't really see porn. Now we have a situation where in the UK, I think the latest statistics are that over 50% of 11 to 13-year-olds have seen porn, and that this is having effects as a result. And that's an example of an industry which has been under-regulated for a long time. So you need to think about obviously different ways of addressing it. I'm not necessarily saying that the way that the bill addresses it is exactly right, but I think there's a role for government in thinking, okay, how do we address this kind of issue? And as you say, as Mallory was very well saying, in striking a balance between flexibility and iterative development on the one hand, and indeed the involvement of an independent regulator rather than government, balanced by a government framework on the other. I think we need to be quite careful about scaremongering. I feel, as somebody who is a champion of human rights, I feel very strongly that this is a very difficult moment for human rights in the UK and in some other parts of the world as well. It is that human rights at the moment is not a popular drum to beat. And I think we have to be careful to be showing that human rights is about striking balances, as you can see on the face of the human rights that we have in the European Convention and that we have in the international covenants, that some rights are absolute and other rights call for a very careful striking of balances between rights and interests. And that therefore, as human rights folk, that's what we should be looking for when we think about the governance of technology issues, so that we are seen as people who are trying to strike balances that work for all, and not as extremists. So that's where I come from as a human rights person looking at governance of technology issues.
I think every single one of you in your comments just now mentioned privacy either as a focal point of your discussion or as something you wanted to go on further into it. And I think that kind of lends itself to a harsh transition, but a necessary one considering the title of the event. A large part of the dissent seems to focus on the monitoring obligation and if it encourages an improper balance of privacy and surveillance. I want to go to each of you here, and maybe I'll start with you, Sam, and then I'll end with you again, Kate, just because I think it might work in a way that will foster a better discussion. Do you think the bill successfully balances rights to privacy and rights to online safety? And do you think discouraging end-to-end encryption or encryption protection is part of the bill? And how does that play into this discussion?
Yeah, well, I think there's a general issue around uncertainty. So by making the legislation quite vague and quite hard to define in many places, it kind of sets a tone where if a technologist is considering innovating down one path, there's a risk that that path could all of a sudden be seen as the wrong type of innovation, and as a result, certain solutions might not get developed in that way. And I think that's relevant to the privacy issue. I think the idea that proactive technologies would be used does seem to not chime particularly well with existing privacy legislation. And I think if you look at the government's record on end-to-end encryption and what they talk about, it seems like every Home Secretary has to make a statement about end-to-end encryption that's completely technologically unrealistic. So the famous one was Amber Rudd a few years back said, "I don't need to understand how end-to-end encryption works to understand it helps terrorists." Now, the sort of general rhetoric around end-to-end encryption, I think, probably will have a chilling effect if it's combined with legislation which does have major implications for privacy. And I think that's what needs to be considered. Perhaps there's a way of implementing the bill as is written that won't have huge impacts in practice on privacy. But the fact that there is a risk that those potential changes could come in will have a real impact in terms of what services do, and how willing they are to cooperate with government, and how willing they are to actually challenge government under different international legislation.
I wonder if, Mallory, you could jump in and just offer just a little bit of perspective as a technologist onto just the balance between privacy and safety that the online safety bill is going through right now.
Yes, thanks. I think there's more to the human rights aspect of this than just privacy. I want to say that from a technical perspective, sort of freedom of expression, right to information, anti-censorship essentially, are very much two sides of the same coin. If you can sort of stay private and keep private what you're accessing online, then it's harder to be filtered or blocked by that. So also noting that for me, technically those two things are tied up, especially because UK, by some measure, is one of the biggest censors in the world. You have a block list exceeding 400,000 domains. So, and it's really ubiquitous. So I don't want to minimize that at all. It's actually quite staggering. And then in terms of the balance, right? So I'm gonna talk about privacy as shorthand, but keep that censorship piece in mind as I speak as well. Because the bill is so vague, and then also I think that specifically around the scanning piece, the tools that are sort of recommended are ill-defined. They sort of have the possibility of being overpowered because they already are. It's not like scanning is new. We see it happen all the time on social media. Others have commented on their own direct experience with that. And the tendency is that they overblock, they're overpowered. So with the bill being vague, it doesn't even appear to be attempting a balance. And that is the worrying part. I mean, without really getting specific, then I'm not really sure where we're introducing that question of balance. It is that this, the scanning piece, especially around privacy respecting tools, it is a fundamental incompatibility. I mean, the idea of end-to-end encryption actually means something. It has a definition behind it. There's, the endpoints that are authenticated to receive and send messages to one another are the only folks who can see those messages, not even the service itself. That is the definition. And so then putting some kind of scanning mechanism, which would lead that detection of content, even if it's a computer, would lead to multiple layers of content moderation processes. I mean, detection is one piece, but then you have to determine certainly that that detection is correct. That sometimes means human review. It means maybe more high-powered AI. And then ultimately, before action is taken, there is often a human in the loop or some kind of appeal or review process. Again, adding people in the loop. So you can see that there is sort of ripe abuse for this scheme would be ripe for abuse, even just in the schematics, not getting into the details of how actually one would scan everything. The question of trying to scan on a device per se before the content is uploaded to the server that then wouldn't have access to it is even a worse proposition somehow, because it means we're turning our user agents, the software and the devices that are supposed to be working on our behalf, into devices that can be working against our best interest. And while we sort of hope for that sort of intervention in cases of criminal activity, the problem is that it will impact all of us. It will impact every single person who's trying to communicate, especially in pandemic times where there's less of an offline world at all. We'll be talking to our intimate friends and family, to our doctors, to our lawyers, to any number of now services or discussions that are happening online more than ever. All of that can now be exposed. So again, going back to that question of proportionality and what do we really want for our world in which our online and offline worlds are very much tied together. Do we want a situation in which it is impossible to have a truly private conversation unless you go outside, walk down the street into a field, and have that with your friend or your doctor or your family? It feels very much like no place is safe to have a private conversation. And I think that mental and social realization for people is actually quite heavy. And it would have a lot of knock-on effects. And so I think it's just out of proportion entirely and totally incompatible.
Kate, I want to offer it to you to see if you have anything you'd like to add to from Mallory's statement.
Did Victoria want to come in first?
Of course, Victoria. Would you like to go ahead first?
Sure. Yes, I'm happy to come in and let Kate have the last word. So my concern is that actually violations of privacy are essentially baked into the bill in many ways. For example, even something that you might think was relatively harmless or perhaps even a good thing, the mandatory risk assessment process. This is going to mean that, so the exact words are that the risk assessment has to take into account the risk profile relating to the user base and the level of risk of individuals who are users of the service. So how are you going to know that unless you are carrying out some quite detailed profiling of your user base, whether that's their appetite for experiencing certain kinds of potentially offensive content, or whether perhaps it might be their propensity to commit these kinds of harmful activities. So there's profiling is going to be going on there. The age child protection element, by default, all sites that are in scope of the bill are to be treated as likely to be accessed by children unless they can prove otherwise, which means, broadly speaking, certainly for very widely used sites like Google, Facebook, Twitter, whatever, that unless you want to access this sanitized version that's meant for children, every adult is going to have to verify their age before being allowed to proceed to access, full fat Google, which is a rather more intrusive way of accessing common internet services than we're used to. And frankly, the British government's trying to get rid of some of the burdens of our cookie pop-up laws. And I'm afraid that's going to pale into insignificance when you have to verify your age just to do a Google search. And then perhaps most worrying of all is the proactive monitoring that's involved in one of the principal duties under the bill, which entails proactive removal of so-called priority illegal content. Now, the issue here is, how are you going to identify priority illegal content unless you are surveilling the entirety of all the content in order to identify the priority illegal content and, in the words of the bill, prevent individuals from encountering it? So censor it at source based on the platform's probably automated sort of view that this particular item of content is priority illegal, which, by the way, in the offline world, for something to be determined to be illegal, we have a lot more checks and balances in the process than any of these platforms will be capable of operating at scale. So essentially, all of this monitoring, the surveillance, the profiling is built into the bill, which I find quite worrying, and as I say, is going to, in some ways, bring any benefits from the reviews to our data protection laws will melt away compared with the intrusive frictions to user experience that all of this is going to bring about. In addition, all of the new terms and conditions and user empowerment duties that we're talking about as well that are in the bill is all going to entail a lot more ticking boxes to accept terms and conditions, to signal your appetite for particular content. All of this kind of thing is actually going to be rather detrimental to user experience and innovation, as we've already discussed.
Yeah, thank you. Lots and lots of points to respond to, so I certainly won't comment on all of them. I think one point, though, is that this is a really complex piece of legislation, a really complex piece of writing, and it's probably quite difficult to get a clear sense from listening to this panel as to exactly what the bill says. And certainly we're not here to summarise all of the content of the bill, but in some ways the bill is quite subtle. So let's just, for example, as regards end-to-end encrypted content, there is no general obligation in the bill to remove end-to-end encryption. That is not suggested in the bill at all. What the bill does do is say that in limited circumstances where Ofcom consider it necessary or and proportionate to do so, they can issue a notice if there is to use accredited technology in order to identify CSEA, that's child sexual exploitation and abuse content, in privately communicated services. So that's in clause 103 of the bill. So it's very, very limited. And what's more, that power for Ofcom to require platforms to do that is a very caveated power. First, there has to be an opportunity for the platform to make representations. Ofcom has to consider whether other steps could be taken instead. Ofcom has to consider the level of risk of harm and its severity. It has to consider the risk that this technology would interfere with users' freedom of expression. It has to consider the risk of breaches of the law on privacy and so on. So there's actually a lot of caveats around that. So just to be clear, there's nothing in the bill which actually takes away end-to-end encryption at a general level or even empowers it lightly at all. And the balance that you're talking about here is the balance between, yes, this really challenging infringement of freedom of expression and infringement of privacy on the one hand, versus the awful harms from sexual exploitation and abuse of children on the other. So that's the balance that is being struck there. It doesn't apply to other content, only in that area. Having said that, I do absolutely take some of the other points that have been made, including by Victoria, as regards monitoring obligations more generally. And I think, although this is only one aspect of the bill also talks about thinking about design of platforms and so on. I mean, to me, the general point that I would make in this whole field is that on privacy, we're not really there yet with technology. I think in the analog world, we have a lot more privacy. As Mallory says, we can walk down the road and have a private conversation, or that there are lots of other ways that you can keep things private. And even when things are scanned, if you go to the airport and your luggage is scanned, that scanning is not tied to the identification of you in any way. If, when my luggage was scanned at the airport, the people doing the scanning says, oh, look, she buys these products, and look, she's using those types of toiletries, and she's reading those books, so we're going to send her advertising on the basis of that, or we're going to pigeonhole her as having particular political views because of the books that she has in her handbag, then that would cause me extreme concern. But the delinking of scanning from identification means that it isn't something that causes us concern. And I think the challenge online is that everything is tracked and linked to identity. And on the one hand, we have obviously strong commercial incentives and strong incentives of AI that you need lots of data. But on the other hand, this is what's causing us challenges. And I don't think that kind of challenge has yet been kind of fully grappled with anywhere. So yeah, there are lots and lots of issues here involving expression and privacy. Yeah, I'll stop at that point. Thank you.
If anyone would like to respond, feel free to, but I will pose another question just to add on to that, which is to tie up our discussion before we move on to audience questions. Do you think there is a way to adjust the bill that would fix some of these issues you've mentioned with regards to privacy or with regards to the discussion at hand? Is there a way that throughout the rest of this process we can make this bill better?
Right, could I just jump back in? Just to stress, I think that is the right question to ask. You know, I think it's easy to criticize what we have in the bill, but we have to be thinking about what we do want rather than just criticizing what we don't. But just to add one point, which is on age verification that I meant to respond to. Personally, I think that age verification is a tiny price to pay for ensuring that our children are no longer exposed to the terrible harms they're exposed to. If, as part of putting in my identity to Google or wherever, having to sign into the service, I have to give my age, or not even give my age, verify somehow that I'm over 18, or do that through a third party so that the information about me doesn't directly go to Google. I don't actually see that as itself as a problem. I think that see that as a healthy price to pay in order to protect our children. But of course, that's a balancing act on which different people will have different judgments. But I'll hand it over to others.
I think a lot of the discussion around online harms kind of reminds me of the classic politician syllogism. You know, something must be done. This is something, therefore it must be done. I think in many cases, it doesn't seem to me likely that the sort of online safety bill style regulation is anywhere near the most cost-effective, the most proportionate way of resolving these problems. Take something like child sexual abuse, right? Is the solution compromising encryption in trying to mandate certain technologies, or is it actually better funding for policing? You know, if you look at how many cases on online grooming are brought by vigilantes in the UK as a proportion of the total, it really shows you there's an untapped market, right? That, you know, why not better funding for the police? I'm sure the cost to innovation of this bill is much more expensive than increased funding for policing on those matters. Things like protecting young people from accessing pornography. Is the solution, you know, requiring everyone to prove their identity online, which is not necessarily an easy thing to do, can be fraught with all sorts of problems. It can open people up to scams. You know, we remember the case of was it Ashley Madison, the sort of affairs website. You know, people killed themselves when their data was leaked from that. Very, very plausible that certain online age verification schemes could lead to similar problems. Is the solution instead better sex and relationship education in schools? I think the sort of trying to see everything through, okay, this is a problem online, therefore it needs a online regulation solution, is a bit of a mistake. I just want to add one extra point. I think that there's a general principle that I think is worth picking out, if you have a journalist exemption in your legislation, it's probably a sign that your legislation doesn't work, right? So California passed pretty hefty gig economy platform legislation. They imposed an exemption for journalists after many journalists objected to the fact that, well, now that I've written 10 pieces as a freelancer for this publication, they're now required to give me health insurance and all these sort of things under their contracts. This is completely disproportionate. Now, as a result, I only get 9 gigs with each of these platforms, and now I can't make a living, right? If the law fundamentally needs a carve out for journalists, it's a sign that something has fundamentally went wrong, especially in a world where journalists and citizens, the line there has been completely blurred.
I can also jump in, trying to be as specific as possible to your question about what changes. Some of it is difficult to say, honestly. It's just, it's going to need either massive just emissions from things that are too vague or whatnot, but specifically, let me get specific. I think that there are some ways, especially on the end-to-end encryption question, that moderation of content and users on the systems can be done without worrying about the content itself, essentially breaking the encryption. We've talked about some of these alternatives in reports. So there's potential to lean into user reporting, which is also something that social media platforms and plain text platforms already rely upon because of the volume of garbage, frankly, on a lot of these platforms. So how could user reporting be done in a way that still respects privacy is, I think, for the most part, an unresearched area that would need some careful thinking, of course, around preserving privacy of the reporter, as well as maybe false positives, false reporting. Another one could be metadata analysis. Now, to be very clear, we would never recommend more collection of metadata or creation of more types of metadata, but already platforms can, for example, even if they're end-to-end encrypted, give some data to law enforcement under a court order or something like that. They typically involve, time of login. Very rarely, in some cases, it's IP address. These kinds of metadata actually can be helpful for identifying spam or other kinds of platform abuse. They could help get some of the low-hanging fruit that is of concern. But we would never, of course, want mandated scanning of content of any kind, even with those safeguards in place. It's just not going to work in the way you think it is. Even if there are limitations that are sort of listed in the policy, from a technical perspective, that capability becomes baked into the code. It becomes baked into the way the platforms operate for users and can be expanded, abused, used at any time. And that's really what we're worried about, because again, this wouldn't just happen for folks who are living in the UK or visiting the UK. It would be global. It would have a knock-on effect for these platforms and wherever their users are located. And then lastly, on the end-to-end encryption piece, in addition to the considerations that Kate outlined for when Ofcom would ask for that notice, we would want to include more considerations that aren't there now, such as security of data, making sure that whatever is collected is then again kept secure. The cost and the practicality of these implementations isn't considered, which it really ought to be. And then obviously the potential for abuse of this technology, not just in the UK, but internationally. So those were some of the things I've already said, but you can sort of erase the whole issue by just not mandating it and incentivizing it instead. And the same suggestion goes for the free expression issues. So removing the obligation for platforms to do this, but rather set forward guidelines and create incentives. Because the issue, and this speaks to very much Sam's point, is that the tendency is already to overblock. The tendency is already to infringe on the right to free expression. We're trying to roll that back, actually. We're trying to help platforms not do this, right? just not overblock. And the point, I think, is that the more vague you leave it, and actually, ironically, the more exceptions you introduce, like for journalists, for example, the more you're asking platforms to make those very difficult real-time decisions. You're putting more power back in the hands of platforms to do this, to follow sort of rule of law and international human rights obligations, rather than the system we have now, which is based on guidelines and incentives that can be influenced by, for example, human rights organizations like ours that can help them make that balance. So I would say that those are some of the very clear changes that we would make to the bill, and that we will publish on soon about exactly what and how.
Yeah, so I would just say that I do think that fundamentally, at a foundational level, the bill is fundamentally misconceived in its approach to the concept of harm at all, which is where this began. It used to be called the Online Harms Bill, and it's still fusing this idea about harm and the concept of illegality in a way that I think is quite unhelpful. And in a way as well, it's about trying to impose technical solutions on societal problems to do with things like bullying and, child abuse and things like that, which perhaps just aren't amenable to some kind of technical fix being applied by online platforms. And as I think Sam was saying before about, why aren't we investing and resourcing police forces to actually investigate these kinds of terrible crimes like child sexual abuse? Just today, the Metropolitan Police, the police authority in London, was placed into special measures, which sort of means an intervention by central government on a police force that's basically failing. And some of the reasons for these steps being taken against the Metropolitan Police was its failures in investigating reports of child abuse. So if we are just failing at a very fundamental level to investigate real life incidents and protect children, I feel like trying to raise it up a level to the online world is clutching at straws, really, because there's been a fundamental failure to address it in the real world. What I would probably keep in the bill, if I had to find something, I don't particularly hate the provisions in there that formalize the way child abuse content is going to be reported to a centralized authority. I think that probably seems quite sensible and might actually help with the real world policing and investigation of these horrific offences. But other than that, I can't really think of a good word to say about anything in the bill or anything that could really be constructively done. Yes, it could be slimmed down. The legal but harmful bits could be taken out. The requirement to proactively scan for illegal content could go. But I think we would still be left with some quite worrying conceptual difficulties about this idea that supposed harmful content needs to be censored at source so that users don't encounter it because it might potentially harm them. I think philosophically, I just have very big issues with that.
I think there's an audience question that would be really good to just close off this panel and give you all the opportunity to finalize any thoughts or rebuttals to each other. It's a UK bill at heart, but the internet is global. So I want to end with what you think the extraterritorial impact of a bill like the Online Safety Bill, if it's enacted or not, would have on the rest of the world, and what your main opinion is on that. Is that going to be a good thing with regards to dealing with online harm, or is it going to be something that could be potentially detrimental?
I can jump in since I think I've said it like a couple times. I won't repeat myself to say that I think this will have a knock-on effect, practically speaking, on users of platforms around the world that would be affected by this bill, and I think that's a negative. I would also say another way that this will impact the global community is that we are seeing copycat legislation in a lot of countries where there are not going to be protections for journalists, human rights defenders, political dissidents, or other folks that we would want to protect because of where they live and the challenges they pose to authority in those countries. And so that is actually a very real risk that we will see now. Large countries that don't have democratic processes in place, that don't have regulators that are going to listen to human rights organizations, essentially pass the same laws and require companies to comply. And that I don't think any of us want.
I agree that where the bill that the bill is likely to have some extraterritorial implications, although in theory it applies to companies when they're acting in the UK, as Mallory has well explained. They're transnational in their reach. And I think, as we saw when the UK's age-appropriate design code came in last year, that did have a knock-on effect on platforms around the world in a positive way. Having said that, I think where there are commercial reasons against international implementation, then the extent of the extraterritorial impact may be much more subtle. Overall, I would hope that through this bill, through the Digital Services Act in the EU, through other positive pieces of legislation, you start to see platforms coalescing to internationally looking at how to reduce harms and create a safe environment. Just to add that overall, I think, as I said at the beginning, for me, the bill is not a step in the wrong direction. It's a step in the right direction. It's something that needs improvement. You asked what improvements we would like to see. I would like to see protection of all human rights rather than just freedom of expression and privacy in the bill. For example, freedom of thought and opinion are very important. Autonomy has been overlooked a bit, I think, in thinking about tech governance. And I would also like to see particular improvements to the sections on journalistic content and content of democratic importance, as well as some other matters. Yeah, I will stop there. Thank you.
So can I just jump in on the extraterritorial question? I think perhaps users in the US will be affected by this, actually, because global platforms like to maintain consistency as far as possible in what they do. And because the EU is pursuing a related but not entirely the same sort of process, although there are some overlaps with things like requirements for risk assessment and appeals and complaints processes. So I think those kinds of things we will certainly probably see being rolled out at a global level by platforms that operate across multiple jurisdictions. I suspect, however, certainly for when it comes to perhaps smaller, more niche services or new startups and challenger services, what we're more likely to see is that they simply will cut out the UK market because they won't wish to expose themselves to this extra bureaucracy and the associated liability with it. So again, similar to the GDPR, where lots of US providers simply blocked access to the UK market, we could see, well, I think that's more likely to actually result in a greater uptake of VPNs, which is something that the drafters of the bill didn't really seem to be catering for, and perhaps we should be grateful for that.
Yeah, I just second the points that Mallory and Victoria have made. I think we've got to be careful with the precedents we set internationally. We've got to remember that we're in conflict kind of with the sort of autocratic world, with authoritarian regimes who very much want a heavily regulated internet, an internet where there aren't protections for free expression, where privacy rights are diminished. And anything we give that effectively allows those regimes to say, well, what about the UK? We're just doing what the UK are doing. That's not a good precedent to set, and that's not going to help activists, our allies. So I'm very concerned about that. And I think, this bill is probably going to mainly come off as a sort of a barrier to trade. We want the UK to be as open to international startups, all sorts of tech businesses. I'd like the UK to be an early adopter nation where, we're the first to take certain technologies, or if something gets made in Silicon Valley but trialed, in London. I don't want to be a situation where companies say, okay, well, we'd like to launch into the UK at some point, but we know there's a lot of regulatory barriers, and once we've hired a compliance team, then we'll come to the UK. That's not going to be good for the UK startup scene. That's not going to be good for entrepreneurship.
I think that's a really good place to end. Don't know if we got a general consensus, but I really want to thank the panelists for pushing on each other's issues and pushing on each other's thoughts. So we could kind of figure out how each of us feels on the online safety bill. I hope the audience as informative as I have. I want to thank every single one of you, including the audience, for submitting amazing questions and for giving such great feedback with regards to this very, very large online safety bill. Thank you so much again, and I'd like to say thank you to the audience and goodbye.